future, if they're a government official, they're not welcome.
What would you like to call it, though? So we can put that on time.
I thought he said prohibition.
Look up. Perfect.
Unless I'm mistaken.
Okay, you're on, Hadassah.
All right, so Bivens notice. This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at today's meeting that is a member or agent of any law enforcement agency of the federal, state, county, city, or township agencies present? And I have to ask 3 times, right? So, asking again, is there anyone in attendance at today's meeting that is a member of an agent or agent of any law enforcement agency of the federal, state, county, city, or township agencies present? And last but not least, are there anyone in attendance at today's meeting that is a member or agent of any law enforcement agency of the federal, state, county, city, or township agencies present? Okay. This is also for a notary, poll worker, school board member, anyone who signed an oath to the de facto government. Raise your hands, your name, state your position. So that goes for you guys too. Don't make me say it again, please. And who wants to say the prayer? I'm not very good at that.
God bless this meeting, and God bless all the folks on this call tonight, and may our decisions come to us wisely. Amen.
Let it be done. Okay, so I guess we're ready to go then.
Go fire away, Glenn.
Okay, well,
not literally, but
right. I've had an issue recently with some taxing authorities that seem to think they can just walk all over me, and so this is county over some land, and so a prohibition is an extraordinary writ. If you read that common law, that WFAA TV case, there's a 2-page article in there by Jesse Enlow, who's a former president of the Republic of Texas, and he talks about some other successes. They seem to be always with the U.S. Court of Appeals at various levels, even though the issues were in state courts. And if you look in their rules, the prohibitions and the mandamuses, there's several extraordinary writs. They're called extraordinary writs. Habeas corpus is actually one of them. But there's other ones. There's quo warranto, there's prohibition, there's mandamus, there's I can't think of the other ones. Sorry?
Replevin.
Replevin?
Okay. Yep.
Yeah, I haven't heard of that one, but I'm not saying it doesn't exist, but I just haven't heard of that one. There's several extraordinary writs. If you look in the rules, the extraordinary writs are all handled by the Court of Appeals. Now, you can actually, in the state, like in Texas, for example, there's a in the Court of Appeals, the Texas Court of Appeals, there is a it talks about extraordinary writs in there, but it the but I don't want to do it in the Texas Court of Appeals. I want to do it in the U.S. Court of Appeals. And so what I basically have is when I go through, I'll go through this stuff that went on with my case, and you'll see what happened. There's a bunch of things that happened, and they just, railroaded me basically. And so a prohibition is a writ to prohibit some government agency from proceeding any further in something that they're doing. And so that's the idea. Is I got a letter from the county sheriff saying they're going to sell my land on the 1st of October. So I'm doing this petition for a writ of prohibition to prohibit them from proceeding any further in the sale of my land. And so we'll see what happens. So under the rules, if you look in the rules of civil procedure, let me, what I ought to do is start sharing screen here. Have I got the rules of civil procedure here? I don't think so. So I'll pull them up. So this is going to be the Fifth Circuit. Oh, well, there it is. It was here. So I'm going to share it. Something's giving me an echo. There we go. The echo went away. Yeah. So what we have is, let's go to the, so this is the Federal Rules of Appellate Procedure along with their internal operating procedures. So what we'll do is we'll just do a search. If you see up at the corner here, I got mandamus. I'm searching for the word mandamus. That's the easiest way to do this because this is like 168 pages. And so, it saves you having to deal with all the rest of it. So then the Federal Rules of Appellate is Rule 21A, Rule 21. And so that's what it also talks about it, expedited appeals or mandamus actions, Rule 41. So this is Rule 21. And the nice thing about mandamus, these extraordinary writs, okay, see, it says mandamus or prohibition. And so either one of them, they're treated the same way. And so it's actually, it's a common law writ, so it's actually quite simple. And that's the thing I like about it. You have to entitle it in re and the name of the petitioner. And you'll see when I go through this Word file, I have a mandamus that I filed that I am using as an example that I'm modifying. Actually, it's a mandamus that I'm modifying. Because it's very similar. It's very similar. The rules are very similar. So you don't have to, normally when you go to the Court of Appeals, the appellant's brief has to have a certain color cover and the appellee's brief is another one. And then the motions, and it's all, you get all these colors that they make you put. And it's really, a major pain in the butt, unless you're in the Ninth Circuit. The Ninth Circuit has a simplified thing for people like you and me, but the Fifth Circuit doesn't. So anyways, so we're talking about the rules of so this is basically, the petition must include, you got to have evidence that you want to attach. Upon receiving the prescribed docket fee, the clerk must docket the petition submitted to the court. The court may deny it. Otherwise, it must order the respondent, if any, to answer within a fixed period of time. So that's basically the choices. And that talks a little bit about other extraordinary writs. This is Rule 21. And I think this is because I did the Form 1020 on them. Anyways, this is a local rule. It has to have a certificate of interested persons, and it references Rule 2821. The certificate that tells you basically how to set up that certificate of interested persons, and it doesn't count towards the page limit. So you're limited as to how many pages. I think it's 7,800 words and 30 pages, which ours will be a lot less than that anyway, so I'm not worried about that. But if the petitioner does not accompany the petition with the requisite filing fee or motion to proceed in form of papyrus, the clerk will, by letter, notify the petitioner of the defect and set a correction deadline. If the petitioner fails to meet the deadline, the clerk will dismiss the petition 15 days after the deadline. So my Form 1020 will fall within that, no problem. Usually they give you like 30 days to satisfy the... But this one, I'm actually thinking about paying the filing fee just because I'm thinking about doing the emergency one because, you know, they're going to sell my land at the end of the month. But, you know, once they get this thing, if I file this thing and they get it, if they proceed anyways, even if I didn't pay the filing fee, if they proceeded anyways, then they'd have to undo it all and they would be in hot water big time. So I'll bet you that once they get this thing, everything will be on hold pending the outcome of this thing. So I'm debating about doing a Form 1022 because I'll serve them with a copy. They'll get a copy once I prepare it, and all of that stuff. So, and then the Rule 22 talks about habeas corpuses. So, but we're not doing a habeas corpus. We're doing the. So then we also need to know Rule 32C2. Okay, papers must conform. Original 3 copies must be filed. So a total of 4 with the court, and then I got to serve the paper 7,800 words and can be handwritten. That's interesting, and 30 pages. And so, which handwritten's it's not a surprise. Oh, and you can do it on amicus curiae too. It's interesting. Anyways, so it's pretty simple. So let's see what 32, where is it? 32C2. So this is Rule 21, 26, 29, 31. C2 A, B, C. Form of other papers. Any other paper, including a petition for panel rehearing and petition for hearing or rehearing in bank, and a response to such petition must be reproduced in the same manner. 32A1 with the following exceptions. A cover is not necessary if the caption or signature page of the paper together containing the information required. If a cover is used, it must be white. Rule 32A7 does not apply. Wow. C1. Oh, then I think it did say C1 if I remember right. 32C1. Let's find that mandamus again. That's Rule 41, the expedited emergency stuff. There we go. 32C2. Okay. So C2. There we go. Other papers. Cover is not necessary. If we use one, it's got to be white. 32A7 does not apply. Right, that's the page limitation. Yeah, it's pretty standard stuff. 8.5 by 11. Bound in any manner not secure. Does not obscure the text. Except for filings by unrepresented parties. Okay, so that's interesting.
Glenn, when did you find out about the sale?
They sent me a letter here the end of August. So I got to get hot on this, but I think once I get this thing filed, they're going to be held up. They can't proceed. So I think I'm, I have a common law court decision. I'll be right back.
I believe his land is in Arizona or Texas, so. That's horrible that they're doing that kind of shit in those states.
So they do have rules. Their rules provide for unrepresented parties, which it probably relaxes the rules a whole bunch. I don't know. I haven't even looked at it, quite frankly. I was just, excuse me, I was just planning on.
Joy first. You know how those cats when you.
I was planning on just doing a standard
If you ever
filing.
you just sit beside you.
The way, just like the other one, and I'm sure I won't have any trouble. The clerks are actually pretty helpful. I've done this before, and if it doesn't comply with the rules, they'll send it back to you and tell you, you need to fix it. And since I'm not a lawyer, they're usually pretty helpful. Anyways, so back to this. So I'm just going to do it on the regular and follow the format that I got. Now, I wanted to, what I need to do is I was going to bring up that common law court decision. Actually, that document by Jesse Enlow, I wanted to bring that up real briefly so we can see what that says. This is actually in that WFA TV It's in the package of paperwork. But I went and saved it as a separate file. So what I'm going to do is I'll share it, and we can go through that. So this is found in that WFAA TV case, and that's in the pinned in this in my on my page there. So you can download that whole WFAA TV, and it'll be in that package. But so this is M. Sminger versus Farm Credit Bank of Wichita and First National Bank of Okeen. The decision of the 10th Circuit, United States Court of Appeals. Okay, we're actually, this is the 5th Circuit, but I have a friend of mine that he's in the 8th Circuit. He's got an IRS issue, and we have a common law court decision for him too. And so these are going to be kind of tests and see what happens, because if this works, everybody needs to know about it, about the power that this has. So anyways, says, to whom it may concern, having read the Warren M. Sminger case and reviewing it with Mr. M. Sminger, I'm attempting to summarize in this narrative the basics of the case in the 10th Circuit decision. This has been read and approved by Mr. M. Sminger. Mr. M. Sminger, with a foreclosure case in progress in a state district court in Oklahoma, filed a suit in federal district court for the Western District of Oklahoma. He was attempting to force the federal district court to convene as a court in law for the purpose of establishing that he, through land patent, had the highest title to his property. It should be noted that this is an entirely new case and had nothing to do with the case in the state court. So he didn't try and remove it. He didn't try and he didn't appeal it. It's just entirely new case. That's called a collateral attack, actually. Anyways, as a matter of strategy, the laws he cited to create a federal question for the federal district court were the patent laws of the United States dealing with intellectual patents or patents on inventions, right? So he definitely did it off point. As he expected, the two banks moved to dismiss for lack of subject matter jurisdiction because the laws cited had nothing to do with land patents. And the district court agreed with the banks and dismissed for lack of subject matter jurisdiction, again as expected. As soon as the district court dismissed the case, Mr. M. Sminger filed a notice of appeal. He did not, however, proceed with the appeal at that point, and the time to file the appeal expired. He then received a letter from the 10th Circuit Court on their own initiative, approximately 2 months later, informing him that they were extending his time to file an appeal. The 10th Circuit Court was, in essence, asking him to proceed with his appeal. This is unheard of in normal appellate procedures, so he proceeded with the appeal. Prior to the appeal, case was heard in the court of the people. Prior to the appeal, the case was heard in a court of the people, the common law court. And this court's decision was filed with the appeal to the 10th Circuit Court. Note, Mr. M. Sminger first declared quiet title on himself, thereby extricating himself from the federally privileged or 14th Amendment citizen status, allowing him to have his case heard in the proper venue. I'm not sure if that is really necessary, but anyways, the 10th Circuit Court affirming the ruling of the district court. I guess it depends on who you are, because what I do is I tell them that Will Livingston, that ratified the Constitution for New Jersey, is my fourth great uncle, and so which makes me right of blood, which would take me out of that too. Anyways, the 10th Circuit Court affirming the ruling of the district court that it did not have subject matter jurisdiction to hear a case for higher title to land. The key to understanding this as a victory is as follows. The order entitled Order and Judgment contains three very important issues. Okay, and he's got a copy of this order here, and we're going to look at it here in a second. It is a fact by statute and by case law that a court of equity does not have jurisdiction to determine legal or highest title to property. It can only determine who has equitable interest, okay? And so they're all courts of equity. And that's why, you get sabotaged. People don't realize that that's what's happening. They can't hear common law. And so you go in and make a common law argument and lose. As stated in the second page of the order, Mr. Ensminger was trying to establish that he had the highest title, and the court knew that it did not have jurisdiction on the title issue, as it refused to convene as a court in law. The order on the second page contains the phrase, "The facts of the court's original jurisdiction exclusive to the people did speak," and was placed into evidence. Okay, that's text. By quoting this statement from the decision of the common law court, the court of the people, the 10th Circuit recognized the decision, venue, and jurisdiction of the common law court. Most important is to follow the asterisks behind the order and judgment to the bottom of the first page to read the statement to which it refers. It says this order and judgment is not binding precedent except under the doctrines of law of the case, res judicata, and collateral estoppel. Okay, so again, so what happens is that's where they get you in these lower courts. Okay, because they're not interested. There's no justice that goes on in these lower courts, and because the law of the case applies. And so the law of the case basically says that if you don't object to getting railroaded and bring up the right issues at the right time and appeal it, then you lose. And you agreed to it. Okay, it's a contract. Res judicata, well, he's going to explain this. Emphasis added. This means that it is binding precedent for res judicata. That means, res judicata means it's decided for all time, which means it has already been decided by a court of competent jurisdiction, and collateral estoppel, which means the opponent cannot bring it up again. Okay, law of the case, binding precedent. So it's law of the case is binding precedent. Res judicata means it's already been decided, and collateral estoppel means that you can't attack it sideways, which is what they did actually in their case, is they did a collateral estoppel on the lower court's case. But it worked. Anyway, so before we go any further, let's go and look at the case. This is it right here. And so you see right here, it says order and judgment, and it's got the asterisks. And then you go down. This order and judgment is not binding precedent except under the doctrines of the law of the case, res judicata, and collateral estoppel. So what court of competent jurisdiction made the decision? The only court involved in this case that made up any kind of decision was the common law court. The district court dismissed for lack of jurisdiction. The 10th Circuit affirmed. Therefore, the doctrine of res judicata in this case could only apply to the common law court. Since the common law court cannot be reviewed, the 10th Circuit could not state that they affirmed that decision. All they could do is affirm the district court's dismissal for lack of jurisdiction. But by quoting from the common law court's decision and establishing that res judicata exists, the 10th Circuit has agreed with the common law court. The people have spoken. The implications of this are truly astounding. From what I've been told, Mr. Ensminger is now in the process of going back to the state court with the common law court decision to remove the case from them and render their judgment null and void. To add to the validity of this understanding of the 10th Circuit decision, it's important to note that there have been other successes incorporating this decision into a judicial notice to other courts and removing these cases to the venue of the common law court. In one such case, James A. Elliott and the United States Bankruptcy Court for the Western District of Oklahoma, the Bankruptcy Court agreed with the common law court's decision and ordered that Mr. Elliott receive all of his property back, even though it had been sold and taken from his possession. I am firmly convinced as more cases are filed with the common law court, we'll see more and more successes in being able to remove ourselves from the oppression and tyranny of the de facto court system of the U.S. and more firmly establish the authority, jurisdiction, and venue of the common law court. And Jay Enlow is, he was former president of the Republic of Texas. So, yeah, they're quoting a bunch of stuff. And it's right here is the other stuff that they talk about in that Court of Appeals. The facts of the court's original jurisdiction, inclusive to the people, did speak and was placed into evidence. So this is, you know, this is what we're going to try and do anyways. I'm going to use their going to try and bring it into the federal court as a collateral attack. And we'll go through I haven't even got the thing finished yet, we can go through it and look at what I have and, you know, take it from there.
How have you collateralized your property, Glenn?
How have I collateralized my property? What do you mean?
Well, that's what it's stated in the case that Mr. Such and Such had collateralized his property prior to all this going down, prior to the judgment. So I'm assuming that was a meets and bounds survey of some kind that drew him to the land.
He brought forward the rights and privileges of the land patent. He didn't say that he had collateralized it, I don't think. I don't remember him saying that, or the case saying that.
Okay, I could be wrong. I'm sorry.
Well, it's the doctrine of collateral estoppel applied, and what that means is they can't come at it from some other side or anywhere. It's they can't attack it at all, period, from any direction. Like with a void judgment can be attacked collaterally. Okay, you can attack a void judgment at any time in any place as a collateral attack or otherwise, directly or indirectly. And so and that's what's happened in my case. It's a void judgment. And so I'm attacking it collaterally with the Court of Appeals. But so this is the beginning of what I've started. Okay, that 97th District Court, and this is the case number, State of Texas Bowie Independent School District. Relator requests the court to prohibit the clerks masquerading as judges in the lower court to sell the relator's land. And so this is basically a mandamus that I modified, and right now I'm hearing that actually where I'm at is the factual accusations that I'm getting into the nitty-gritty detail of what went on, and then there'll be the argument. So I haven't even got to the argument part yet, but the statement of the case, the issues presented. First of all, this court has jurisdiction under Federal Rules of Appellate Procedure Rule 21, and I can probably take this out of there. We actually used this for a case with a friend of mine with the IRS, and he was in the 8th Circuit with the mandamus. So it's just a few modifications. Relator herein requests the court to prohibit the clerks masquerading as judges in the lower courts from selling the demandant's land. Relator exchanged silver coin for land as evidenced by the grant deed. Actually, I had to add in a bill of exchange because it was a grant deed, and respondent sent relator extortion threats in the mail, threatening lawsuit. Relator sent respondents a notice and demand explaining the felonies they were engaged in and demanding a bona fide contract by which the relator had agreed to their extortion. And maybe I'll probably tone this down a little bit. Maybe agreed to their tax. Respondents failed to respond and eventually filed a lawsuit as case number above. Respondent court had 2 different addresses published on the internet. They did. Relator filed a challenge to standing, a notice of default, and opportunity to cure. Actually, it's a notice of default. And a final notice of default. Respondents failed to respond. Relator filed 78 criminal complaints into the case against respondents, served a copy on the U.S. Attorney, the Federal Bureau of Investigation, and the Texas Department of Public Safety. Respondents failed to issue warrants as required by Texas Code of Criminal Procedure. Relator filed a demand to disqualify the judge. A new judge appeared in the case, who also failed to issue warrants. Respondents notified the fake court that relator had appeared in the case and set it down for trial. Relator filed a challenge to jurisdiction, stating that the respondents were bearing false witness because the relator had not appeared in the case. Relator sent a challenge to jurisdiction to one of the addresses shown on their website, and they failed to get it from the post office, and it was returned. After the show trial, the clerk sent an email saying that there was an order, but the relator would have to pay fake money to get it. On or about the end of August, the relator received a letter from the county sheriff stating they were selling the relator's land on 1 October 2024. So anyways, that's where it is. And so then this part of it goes into a lot more detail about what happened. And I haven't finished that, and then the argument. But the argument's going to be pretty straightforward because I have the right to own land, and it's a denial of due process, and all that stuff. And I challenged jurisdiction, and they denied me due process by refusing to accept it. And so we'll see what happens. And then I'll bring up the common law court case. And I think the common law court case is going to be the silver bullet, quite frankly, because they got no answer to that. So we'll see what happens. This will actually be a good test to see how powerful or if these common law court decisions are going to work. There's another friend of mine that I'm helping. And we're doing a petition for writ of mandamus for him because we were thinking about a petition for writ of prohibition, but we decided he's in the 8th Circuit, and in the 8th Circuit, it says that for mandamuses, they have 14 days to respond in the 8th Circuit, and they have to either deny it or order the respondents to answer. And I think that it'll be better for him to do the mandamus because we still got that common law court decision, and that common law court decision, we went through some of them here before. We went through one last week. Quite frankly, the common law court decisions are really, in a way, they're a complete denial of due process, if you think about it, because we don't invite them to come to the proceeding. But you have to also understand that they can't come anyways, even if we did invite them, because they'll only come by attorney, and an attorney can't come into a common law court proceeding. If their attorney shows up, we tell them, get the hell out of here. And so their attorney can't come, can't talk to the court. The attorneys know it, so they won't. So it is a denial. So it's a denial of due process insofar as the felonies that they're involved in are involved. But at the end is a $1 billion judgment, and that's not a denial of due process. The felonies are involved are just evidence of the denials of due process, and the record speaks for itself that they deny due process. That's all they know how to do. They do it all over the place, and so they never follow their own codes. They deny due process on a routine basis, and it's all over their own documents, and so you just use their own evidence against them, and so it makes it so that the judgment, the $1 billion judgment, and the facts. Okay, the facts are still there, and they may not have been found by a jury. Actually, they did get found by a jury to be guilty of those facts. But the issue of the facts of denial of due process, okay, that they did deny due process, they lost subject matter jurisdiction. They're, I mean, all of that stuff, it's all to show those kinds of facts. And then at the end, we start throwing in a bunch of and this thing quit sharing.
I got roboted there for a little bit also, so I guess.
Yeah, so somebody's interfering. They don't like me talking about this stuff. Anyways, so what you'd have to do would be go and arrest them and put them on a trial and hold a trial as far as and get another jury to find them guilty. As far as the felonies and the jail time or getting their neck stretched and that kind of stuff would be concerned. I wouldn't, the only thing is that it just gives you evidence of their denials of due process and the fact that they didn't have a court and it's an administrative proceeding and they don't have authority. There's actually court cases that say that administrators cannot do anything that affects life, liberty, or property. There's actually a recent Supreme Court case with Thomas where he talks about it. Anyways, I'll be back in a second.
That's interesting. A recent court case where they talk about not allowing the administration.
So anyways, was somebody saying something there?
I was just saying that's interesting. A Supreme Court case where they're talking about not allowing the administration, like but I can't say it as well as you, but you just mentioned a minute ago.
They can't affect administrative judges can't affect life, liberty, or property, and they're almost all administrative. Only an Article 3 court can affect life, liberty, or property, and if they're not an Article 3 court, then they can't affect life, liberty, or property, and rarely are they operating as an Article 3 court. So anyways, that's what I'm working on is a prohibition, get him to prohibit this auction, the selling of my land, and it's never over, even if they did sell it. They still have to the burden's on the buyer to prove that he bought something, and so it ain't over by a long shot. I don't care if it's a sheriff's sale. That sheriff didn't have authority to sell that land. Anyway, so probably what I'll do is we'll see what happens. We'll see what happens with this prohibition. I would be surprised if they proceed with the sale. Until the Court of Appeals answers the prohibition, and no matter what with this common law court decision, there's going to be $1 billion lien against these pirates, and so we'll see. it's a crapshoot at the best of times, and all you got to do is just do the best you can. You know, you can't. It really makes my blood boil sometimes. You know, don't get me going. I feel like I want to. You have a right to resist an unlawful arrest with lethal force if necessary. You have a right to resist slavery, and this is slavery with lethal force if necessary. And so, you know, you almost want to. Well, you got to be careful what you say and do. You know what I mean? And so I just accuse them, and we'll see what happens. You know. So I'll keep you posted about what happens with it. I've been tossing around whether I'm going to do an emergency one or just a regular one. So we'll see. If I do a regular one, then I'm going to do the Form 1020. I'm not going to pay the filing fee. I already went to the Fifth Circuit one time without paying the filing fee. I did the Form 1020, and after I got the process done, they sent me the scheduling order. So I know they know all about it. You know, they might not even, if I send it to them, they might not even send me a letter saying that there's a filing fee, because they know this Form 1020 is going to come. So we'll see.
Good approach, Glenn. So this paperwork is definitely going to hold off and put a stay on that sale at least, correct?
You just never know. I mean, I would be surprised if they proceed, but if they do, and then I get the prohibition, then they're going to be in a bad way. And even if they do, I'm preparing a lawsuit in federal court, you know, right now against them, and I'm going to be bringing up all those issues that I'll be bringing up in that lawsuit, and you know, I had a property tax case in Arizona that I filed a lawsuit. I named the attorney general along with the pirates in the county, and the assistant attorney general removed it into federal court, and he said because I was alleging that federally protected rights were being violated, and they were. So what happened is I didn't want it in federal court, and so I got belligerent and started dumping on the judge, and they dismissed it immediately. But my property tax issue went away, and I never heard about it again. So I think that bringing up the federally protected rights in the federal courts is it worked in Arizona, and I didn't even bring it up. But anyways, so you know, we'll see what happens. Does anybody have any questions about what we're doing here, and about anything else we're doing? The common law courts. I'll tell you, the common law courts is the only way to go. It's really, and if you can get it into the federal courts, that seems to the state courts are just a bunch of crooks, and you really need it. You know, it's hard to say. I'm not a very trusting sort, even in the local district courts, federal. But the Court of Appeals have to uphold the appeal, the case law, and so they cannot ignore it like they do in the lower courts, or they're at least less likely. I've never seen them do that. They're usually pretty correct on what they do. You got to bring up the right issues, and so this is a collateral attack.
Yeah, you said that about my case in 2018. Same thing. So I'm so sorry that occurred. This is occurring, and on the plate for you. Can you give us some updates about what happened last Saturday, and did you discuss your case at that time?
What happened is there was only one notary there, and that was me. And so the document needs to be notarized, and so I can't notarize my own document. But I've got some seals made up, and we're going to have some new notaries at this one tomorrow. And so hopefully we'll be able to, because I got to present my case. And I've actually got about 3 cases I'm planning on presenting, and at least two, maybe 3. We don't have anybody else's case right now, although there's one case that we got that he's having trouble with, and so we might see. The problem is we used a different seal than was used in that Dallas case. So what we did is we made up a seal exactly like that Dallas case that was successful, and so we're trying to make it so that we're more likely that they'll recognize it, and before we had Republic of Texas Common Law Court, and that's really a foreign jurisdiction, so they can sit there and play stupid with that. But when it says our one Supreme Court, that's found in the Constitution, United States of America. It's hard for them to play stupid with that one. You know what I mean? And so, we'll see.
Yeah, that's where you get judges starting to recuse themselves off the bench and run and take off their black robes and run in the back room, call excessive recesses.
Yeah.
Hey, Glenn, who is bringing the action against you? I got on a little bit late. I've been on here for about 15, 20 minutes, but I just didn't hear the beginning.
Who's this?
It's Shara.
I'm not even seeing you in the list of people that are on here. Oh, Shara, I see you there. Okay.
I'm let me see. I'm down there at close to the bottom. I think.
Okay, so what's your question?
Oh, I just wondered, who is it that's bringing the action against you? Is it a servicer or a trust company, or who's the?
It's a county tax assessing authority.
Oh, okay. Oh, I'm so sorry you're going through this. I'm going through the same thing, but it's a service.
Which state are you in?
I'm in Kansas.
Okay. But so it's not the county taxing authority, it's a servicer, so it's over a mortgage?
Yeah.
Well, you could still, again, these court cases have worked against mortgage holders and stuff like that. That document I just read is in that WFAA TV case that's pinned at the top of our chat on this page. I would say download that thing and read it, and read that, especially that it's only like 2 pages and the court case are with it. Read that thing, and it'll give you some ideas on how you can proceed, because it's worked against people, these mortgages, foreclosures, bankruptcies, all sorts of stuff. That's what that Jesse Inlow talks about in there.
Okay, cool. I'll read it for sure.
Yeah, and then you got to get 12 people together or 14 people together so that you can convene a common law court.
I have no idea how to do that. And they've already got a summary judgment that's just completely bogus. Completely bogus. I was denied due process and everything. It's already paid off. Anyway, I kind of went through all the same thing you did as you were reading through all the things that you had done. I was like, oh my gosh, I've done all that too.
So the important thing is you need to get a court seal. I would get one just like the one that's in that case. I got it designed and made at Staples, and I also got a notary seal. Now, if you look at the notary seal, it says Texas State on it. It says notary, and it's got the guy's name, and it says Texas State. Now, the important thing to understand about that is Texas State is not state of Texas. And so you don't need to follow their rules, whatever their rules and regulations are. You don't need a commission. And in fact, what I did was when I got one with my name on it. It says Texas Republic, and the Staples said we need a commission or something showing that you have authority to do that. And I said, well, that's not state of Texas. Read it. And so then they gave it to me, no problem. So again, you might have to explain it to them, but it's not state of Texas. And so if it's not state of Texas, then those rules don't apply. And same thing with Kansas, okay, or any other state. If you're not state of Kansas, if you're Kansas state, that's not state of Kansas, okay. And so then all of a sudden, where's the rules for that? There aren't any. That's we the people again, okay? So I would suggest you read that thing carefully and look at that seal, R1 Supreme Court. Why is that R1 Supreme Court? Think about that. You think that the Supreme Court of the United States in Washington, D.C., that is run by a bunch of bar members, is a lawful de jure Supreme Court of the United States?
No,
Absolutely not.
it's not the Republic.
That's right. So we, the people, need to start stepping up.
I agree with you, sir. 100%. I won my tax court case at lower level. In the meantime, I was facing divorce and 2 other cases. Also, I had an open court case in United States court, and I won that one, thank God. And let me tell you something, that 1040, it does wonders. So I agree, definitely.
1040?
The 1020, sorry, the 1020.
All right, thank you. Good. Yeah, that's powerful.
Exactly.
That thing is amazing. And Kerry Zolman's the guy that figured that one out, and he's brilliant. He's had a stroke, and he's just not himself, and he's brilliant.
Mm-hmm. Yeah, I took a couple of his classes.
That's a homemade form.
It's a homemade form.
No, nice.
Yeah. He gave it to me, sir.
Thank
He
you.
also gave me, he gave me the privilege. I have the privilege of holding his book that he wrote.
Right on.
So yeah, Kerry Zolman knows me. Yes, very well. And I'm sorry that happened. Yes.
He is not himself. Yeah. He doesn't even know how to do his book anymore. He's had a stroke, and there's people wanting this book. It'd be nice if maybe you could digitize his book and send it to me, because there's people that want that.
Wow. I shouldn't have said nothing. No, he did tell me not to ever sell it or share it. So I'm going to keep my word, sir. I'm sorry.
Well, I understand that. I see him just about 2 or 3 times a week. And you know, so he's just not himself. I think that, but whatever, you have to do what you feel comfortable with. I don't fault you for that.
Maybe could you ask him if he wants you to carry on his flame, his passion? You two guys, that's probably what he was thinking too.
Well, and yeah, maybe I'll talk to him about that. At any rate, he's not himself. I mean, when you start talking to him about the law, I mean, he pipes right up, he wakes right up, and he starts bringing it up and bringing up all the issues and stuff that he normally used to do. But you ask him if he remembers if he has any of his book around and if we can get a copy, and he says, "What book?"
Wow, that's so sad. Let me tell you something, sir. I had the privilege and the honor of meeting a couple of his comrades, and I know him very well. Exactly. United States Code 1, subsection 1. I learned it from him. He's a very well, he's a good man. He was a good educator, and I really respect him highly. When I heard him, he got sick, I was very, heartbroken.
Yeah, I know, and so were we all. It's nice to be able to still go out, and we go out to dinner, to lunch, probably a couple times a week, and so it's nice to be with him and get him out of his house and help him, feel have friends around. But I think that if it wasn't for us doing that kind of stuff, he'd probably be in worse shape than he is. But at any rate, thanks for the testimonial, and that's great. I'm very happy that it's working so good for you. I have a YouTube video, actually 2 or 3 YouTube videos about the Form 1020, and forms are available in the show notes of those videos, and you can download the Word files. You cannot. Don't ask me to get access to them. You don't. That's not how it works. Those are Google Docs. When it's a link to a Google Doc, and you download that file, and then you manipulate it on your hard drive. I'm not going to give anybody access to manipulate it on my Google Docs, and so that's the only way that it's going to work.
Guess who I didn't mean to cut you off. Guess who the parties were that were coming after me? Guess who the agencies that are responsible of these taxes? It's the Independent School District, and who else? Oh gosh, I need to look up I can send it to you, sir. That way you know that I'm legit, and it was a great win. It was very hard. Very hard. On top, I was raising my 2 children. Bye. Love you.
Yeah,
I was raising, so it was very rough. I did it all by myself.
Well, I've been there. It's like a feeding frenzy sometimes. They're just coming at you from every direction, and so I certainly understand where you're coming from. I've been there. And there's people I know that are in that situation right now, and you just got to help them one step at a time. And that's all you can do. So I definitely understand where you're coming from. So I'm glad that the Form 1020 worked out. I mean, that is an amazing form, and I like it because it's short and sweet. It's only 2 pages long. And it cuts to the chase, and they can't argue with it. I've used that Form 1020 with the IRS, and
Exactly.
What happened is I didn't even have to do the default. I sent them the first one, and they just come back and said, since you're such a good customer, we're going to forgive you.
Sir, I laugh with you because let me tell you something. I defaulted the lower court. I sent just the plain 1020 registered mail, a return receipt 3 times. Then I defaulted them, and that was it. That's how powerful that 1020 is. And I hardly ever speak about it, but that's the reason why I win most of my cases.
Yeah, well, what I do is I send them the Form 1020 by certified mail. And then the second time I sent them just a 1-page letter and say, you failed to respond. So therefore, under the Uniform Commercial Code, you have to discharge this debt, but I'm going to give you another 5 days. And I sent them a notice of default and opportunity to cure. And after 5 days, I sent them the final notice of default. I don't owe you anything. And I did it with the U.S. Court of Appeals for the 5th Circuit. And after I didn't finish the last one, they sent me a scheduling order.
Wow, that's amazing.
What's a scheduling order?
When you go into the Court of Appeals, what happens is you file a notice of appeal. This is in the federal courts. Other state courts might be different. In the federal courts, you file a notice of appeal in the district court. When the district court is finished, you file a notice of appeal. You have a period of time that you can do that. You file a notice of appeal, and then when you file a notice of appeal, the Court of Appeals will send you a letter and say, we got your appeal. You need to send us a filing fee. And it's a couple pages. It gives you some brief instructions and things like that, but it's basically a letter telling you have to pay the filing fee. And so then what I did was the scheduling order. Once you pay the filing fee, they'll send you a scheduling order. A scheduling order tells you when you have to have your appeal brief done. It says when the appellees, you're the appellant. It says when the appellees have to have their appeal brief done. And it gives you time frames as to when, if you're going to respond to their brief, it gives you time frame when you have to do that. And so the idea is they want to move it along and get it out of there. And so it tells you when you have to have it done by, when you have to have your different briefs and things like that done.
Cool. Well, thank you. The 1020 form, someone just made it up and called it a 1020 form? I mean, I haven't read it yet, but I'm going to.
Yeah, that's what it is. It's called a 1020 form. It's Kerry Zolman just made it up. It's a homemade form, and he calls it the 1020 form.
He's brilliant. Well, just like the IRS has 1040, 1040-S, 1041, 1041, he's
we can just make up our own forms.
Brilliant. Exactly. Because they are the tax experts. And what we are the living, breathing woman and man. And well, anyways, long story short, yeah. So they can't level up to us because we don't have a title, but they do. They're tax experts. And what these courts are, right, Mr. Glenn? I'm sorry, Glenn, are tax courts at the end of the day.
Yeah, they're all de facto, and because we the people aren't stepping up. If we the people step up, they have to step aside. Ex parte Milligan talks about that. The Supreme Court in Civil War era case that talks about the martial law and the martial law courts is that they have jurisdiction because we're not stepping up. And when we step up, they have to step aside. And that's what happens when we file our common law courts. We sit down and we have our common law juries. And so we're not only helping ourselves, we're helping our friends and neighbors. And the more successes we have, then people will see it and then they'll do the same thing. And that's the only way we're going to ever see any justice. And when we do that stuff, it doesn't matter what happens, what these pirates do, because they can't make the Constitution go away. And we, the people, have the arms too. Okay. That's why the militias, that's our Constitution, such an inspired document. But we need to step up and we need to defend it. And, otherwise we're going to wind up slaves if we're not careful.
Yeah. So let me ask you a question. Have you ever, or is this a good idea, an ambassador, you may know this as well, to do a revocation of powers of attorneys into the court for the attorney, the opposite party and the court itself, that since they're administering our estate? So should we put in a revocation of their power of attorney over our estate? Since, I've got a power of attorney over it and I've got a CAF number and I've got my estate EIN and everything.
That thing does exist, but if you show that you're doing that kind of stuff, then it's a fraud. And if you participate in a fraud, you can't claim fraud anymore. And there's all these court reports. What do you mean by that?
Oh, by admitting that they even have power of attorney?
By talking about that estate. Okay, the only thing I talk about that estate is I talk about that they're assaulting me with their minor estate. And it's color of law. But if I go and say I've even seen people do it where they'll go in and they'll make a good law argument, and then they'll say, and I got this birth certificate authenticated. And the judge will look at them and say, you're crazy. You don't know what you're talking about, because you cannot mix your law. Number one, you cannot mix it. You're talking law, and then you're talking admiralty, and you cannot mix it. In the Causes and Necessities Taking Up Arms, 1775, the Continental Congress said that the king has extended the courts of admiralty and vice admiralty far beyond the ancient limits to supersede the course of common law and to publish and use the exercise of martial law. So martial law supersedes common law. So if you start arguing martial law, then you can't go back to common law when in that particular case. And you have to know what you're doing if you're going to argue martial law. But so the best thing to do, in my opinion, is to stick strictly to common law. Now, a common law court can bring up some of that, but again, you cannot, if you try and capture that thing, you do not have clean hands. And what I tell them is I want that thing dissolved and liquidated yesterday, and I don't give a shit what you do with the fake money that's in that account. And because you got to have clean hands. I don't want the fucking money. They'll probably have to give it to me because they can't give it to anybody else if they did dissolve and liquidate that estate. But I tell them, you can put it up your rectal orifice for all I care. And because otherwise I don't have clean hands and I can't claim fraud. And so it is a fraud. It was set up unlawfully and illegally. They didn't tell anybody about it. It's a complete fraud. And you have to be careful about that.
Oh,
Did
okay.
you
So
say-
you're saying that they set that the estate that they set up with our birth certificate was done fraudulently because they, obviously didn't tell us or give us disclosure. So then if we go into the court and say you're administering that estate, then I'm participating in that. Is that what you're saying in a nutshell?
Yeah, exactly.
Mm.
Are you also saying, Glenn, that you earlier said you only use it when you say you're attacking the minor estate or something like that?
I tell them they're assaulting me with the minor estate because it's color of law, and that's a felony. It's a felony to violate your rights under the color of law. That minor estate is found at 31 Code of Federal Regulations, section 363.6. All regulations are by definition color of law. I've talked about this before. In Article 4, Section 2, it says Congress shall have power to make all needful rules and regulations respecting the territory or other property of the United States. The regulations are for property of the United States. If you're subject to the regulations, you're owned by the United States. That's what a slave is. So if you want to participate in that, if you're subject to the regulations, you are a slave by definition. And so, again, you don't want to go there. The best thing, what I do is I tell them that that thing is color of law. It's a felony. You're violating my rights under the color of law. You're assaulting me with that minor estate, and it's a felony, and you're conspiring to do it, and that's conspiracy. And that's where I go with it. And I want nothing to do with it. I want it dissolved and liquidated yesterday. And I don't give a shit what you do with the fake money. You can put it up your rectal orifice for all I care.
But you look at how they use it to attack you. That's interesting. Thank you.
Well, that's exactly what they're doing.
But it's
That's
also,
exactly what they're doing.
But it's also where everything is funded, right? I mean, where everything is funded from.
That's
all of this. So
that's immaterial.
Well,
That's
I'm just saying,
immaterial.
should you not be able to use it to set off then, something in court?
So you want to participate in the fraud then?
No, I'm truly asking.
Well,
a
no,
question.
you're
I'm not
justifying
arguing.
it. That's called rationalization.
I hadn't thought about it that way, to be honest with you. This is the first time I've heard of it from that perspective.
That's called rationalization. You're justifying participating in the fraud. The judges see that stuff. They know exactly what's going on. That's all they do.
So
And
then,
and so
Is
then
it
are
wrong
you
to use
putting
someone's weapon against them, someone's own weapon against them? Okay, I'm just thinking out loud.
again, your weapon is the law and the fact that it's a fraud. If you participate in a fraud, you can't claim fraud anymore. I don't participate in a fraud. And I don't care how you want to rationalize it. I don't care what they do with the fake money. They can put it up their rectal orifice for all I care. I don't care. And the what they're doing, you realize what's going on with these wars, okay? What there's going on with these wars, the reason they're having these wars is because it kills people, because they can collect the money out of the minor estate. The banksters get to collect it and set it off against the national debt. So you want to participate in that?
Not at all.
So then why
Never.
shouldn't we be going in and just discharging these cases, just discharging them?
No. You know, you keep talking about that. You're talking out of both sides of your mouth. You know, you go in and talk like that to a judge, and he'll tell you you're insane. You know, and under Title I, Section 1, Carrie Zolman used to talk about it all the time. Under Title I, Section 1, it says, in compos mentis is insane. Do you know what in compos mentis means?
No.
In compos mentis means you're incompetent. You don't know what you're talking about. That means
Mentally
you're
incompetent.
insane. So the judge is telling you that you don't know what you're talking about, and he's saying, I'm going to send you to a shrink to have your head examined.
Thank you for that. I hadn't even seen it from that side, from that point of view, you know?
I mean, it's
It's
probably
up to
worked for
you.
some waving their birth certificate in the courtroom. I think I've heard a couple stories, but thank you.
I never, ever, that stuff is a fraud. It's a fraud from the beginning. Fraud obviates the most solemn promise to pay. There's lots of court cases that talk about that. It's a fraud. If you participate in a fraud, you cannot claim fraud. If you participate in a fraud, you're incompetent. You don't know what you're doing. They send you to get your head examined. That's what the judge is saying. If he's a good judge, he'll tell you that. A lot of them will sit there and play stupid, and they won't say a word, and they'll rule against you and let you figure out what happened.
Is that how Corey rolls with it as well, Glenn?
Sorry?
Was that Corey's take on the whole aspect about the trust as well?
Who's Corey?
I'm sorry, Carrie.
Oh, Carrie Zolman.
Yes.
He doesn't recognize the trust. He doesn't talk about the trust. He basically just deals with the IRS, you know. He can tie them up in knots. He uses words against them. Okay. In other words, it's all down to the definition of words. Okay. He doesn't even talk about the trust. He doesn't talk about it at all.
Yeah, I remember.
And,
I've never heard him say that, but I remember him. It was reported that it took him 4 or 8 hours to answer 4 questions in court.
Right. Yeah, he was charged with willful failure to file, and his last name was Zolman, starts with a Z, and so he was the last guy of about 40 people that got arrested, and it took him 8 hours just to get his name out of them, and he would just tie them up in circles. He came in there. And the lawyer was going to represent him, and he said, well, I got this contract, and he gave this lawyer this contract, and the contract said, if you do what I do, if you do what I tell you to do, and there's a sentence of jail or whatever, I'll go to jail, but if you don't do what I tell you to do, then and there's a sentence of jail, then you get to go to jail. And the lawyer said, well, I can't accept that. And so then Terry had to speak for himself. And so then the judge says, what's your name? And he said, well, my dad calls me Bubba. and it took him 8 hours just to get his name out of him. And the prosecutor would say yes or no, and then ask him a question, and he'd answer yes or no. And then she'd say, so what did you think I meant? And he said, well, I thought you wanted me to come over there and pull your dress down and see what's under there.
Well, you know, for the past couple of years, I've been bugging you about his library or his glossary page, because he was telling it, reporting that he would go to court with his glossary page and say, these are the words that I use, and anything other than that, I don't understand it. I only understand these words.
I can send you his glossary page.
I know you did already. I bugged you for about a year, and
can we put it in the chat? Is it long? Or
no, it was something that well, that's up to Glenn, but
well, what he did is he would say, I got this glossary, and it's just standard Black's Law Dictionary definitions, what a person is, but it doesn't matter what it says, because they'll never accept it, because they're using the words against you. They want the double meanings. And so they're sitting there using all sorts of words against you. And that's why he ties them up. He said, do you have a red dress? What's red? You know, everybody's interpretation of red is going to be different. What's you all mean? Well, and you all means that me and the girls are going to go out and have sex. Whereas in Minnesota, it means something completely different. And so I mean, it's down to the words on what it means. And that's why it took him 8 hours just to get his name out of him.
That's brilliant. He's a very brilliant man.
And very humorous too. Sounds like good humor.
Well, he tied them up in circles. They went and finally, what it came down to is the table of parallel table of authorities. It's in the 1040 booklet, the instruction booklet. It's under the privacy statement. It says our authority to collect this information is found in, and it gives you about 4 sections in the Internal Revenue Code. And if you go to the parallel table of authorities and look up those 4 sections in the Internal Revenue Code, they're found in Title 27, United States Code, which is alcohol, tobacco, and firearms. In other words, the IRS doesn't have any authority for income tax, and they know it, and that's what it came down to. So they found him innocent, and he went home. He was in his pajamas. They went and arrested him in Houston and flew him to Dallas and put him on trial. And so when he left the court that day, a taxi driver drove up, and the taxi driver says, "Are you the guy that just got found innocent?" And he said, "Yes, I am." And the taxi driver says, "A free ride to the airport for you." And so who knows? Somebody paid for his taxi to the airport, and that's what happened.
Well, wish him well for all of us, even if he doesn't want to speak on law.
I will.
Doesn't give a shit about it anymore. But you know what? I kind of don't blame him, because this stuff can kind of wear you down. But it is really, really hilarious when you look at it. Their game. Yeah, so does anybody have any other questions for Glenn tonight? He's updated us a lot on everything, so I don't want to wear him through, so he doesn't want to join us again, because I certainly do look forward to this time that he gives us. So I'll let anybody say their last words, or whatever Glenn wants to do. Go for it.
Yeah, let's go ahead and wrap it up.
I'm sorry, I was going to ask, what was the YouTube channel where you go over the forums or explain the forums?
My YouTube channel is Sovereign Living, all one word.
Okay, thank you.
And if you look on my where I'm talking on this chat, it has the scales of justice. My YouTube channel has the same logo.
Okay, thank you.
And you said, Glenn, that you have 2 segments that you're speaking on that, correct?
There's actually 2 or 3 videos on YouTube that talk about the 41020. If you go to my website, there's a my website is maybe I'll pull it up here and then you can see where it is, and share it.
That would be great. And then I want you to stick large poles up those orifices of those folks that are thinking they're going to do anything of any kind of sale.
Yeah, I'm going to try and break it off in their ass, that's for sure. This is my website. If you go to the free videos, those are links to YouTube videos. And let me show you. So, and they're organized by topics. So I've got over 500 videos on YouTube. And YouTube has actually taken a few of them down, not too many. But so some of them might not work, or it'll go to a page that YouTube says this video is not up anymore. But most of them are still up. And this is not all of them, but this is most of them. And so that's basically my YouTube. These are that's my website. And what I do with my YouTube videos, a lot of people like to get the court citations, because I go through a PowerPoint presentation and then I explain the court citations. And so what I do is I take those PowerPoint presentations and convert them into PDF files. And all those PowerPoint presentations are either, they might be in the show notes of the YouTube videos for the more recent ones, but they'll otherwise be right here. There's a lot of other files here, but these are all free files. But as you see, there's do-it-yourself kangaroo courts. Those are the PowerPoint presentations turned into a PDF file. And so, and then there's forms, the copyright truth affidavit, notice and demands. There's all sorts of forms, generic forms that you can use that I talk about in my videos. And then there's also a few books and stuff like that are here too, like the Scientific Principles of Improvised Warfare and Home Defense. So there's a few books. There's about a gigabyte worth of files right here, and you can download them. So that is found on my website where it says read files, and you can download them.
Thank you. Dad calls me Bubba.
There you go.
I believe he was going to go for life. He was going to go to prison for life. And then he...
Who was that?
Carrie Zolman.
Well, no, what he did, they offered him like 8 years or something like that. And he said, He said, I won't settle for anything less than 108 years. And he was playing games with them. And so, you know, they tried to plea bargain with him, and they wound up dismissing it.
Yeah, and then that's where he did the answering the questions of his name that took, you know, basically 10 hours of a court's time in Washington, D.C. So they were ringing it up big time.
Yeah, they're all D.C. courts. You know that, right?
You explained that to me long ago, but give me a refresh if you have the time.
Well, they use a zip code, right?
Right.
All zip codes.
Yes.
All zip codes are regions in the District of Columbia. So it's not, I used to say that it was territorialism, but it's not. It's actually District of Columbia, and it's Commerce Clause. And so under the Commerce Clause, you have no rights. It's a dictatorship. And so what they're doing is they're bringing, that's one of the felonies that I accuse them of. They're perjuring their oath. They're bringing the District of Columbia outside of a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17. So it's not only the zip code, it's also the use of Federal Reserve notes. If you read in the Gold Reserve Act of 1934, Federal Reserve notes are meant for the District of Columbia only. And it's also, if you go to the, that's codified at 12 U.S.C. 411, and 411 says that they're meant for the banks only and no other purpose are authorized. So they're bringing the District of Columbia outside of 10 Mile Square in violation of Article 1, Section 8, Clause 17. They're using the Commerce Clause. That's why they have to get that minor estate. They have to get the minor estate. That's what they're assaulting you with, because that gets them into the Commerce Clause.
Yeah, that's correct. That's correct.
So do you talk about the major estate? Is it private, or we don't talk about that much here?
The only thing I say is they're assaulting me with it. And they're bringing the District of Columbia. You got to stick to strictly the law. You can't argue with the minor estate. I just tell them they're assaulting me with their minor estate in violation of Article 1, Section 8, Clause 17. And I demand that it be dissolved and liquidated yesterday. And I don't care what you do with the fake money. You can put it up your rectal orifice.
The rectal orifice thing is new since 2018, but I totally understand.
You know what the rectal orifice is, don't you?
Being a nurse, I certainly do. I've given enough enemas in my day.
Would that be the bubble?
There you go.
But
You
anyway,
can put it up.
go ahead, sir.
You can put it up your ass.
That's what you used to say. Good job. Thank you so much for all that you've brought to the table tonight, Glenn. I really, I appreciate your time and energies. So I want to end with a joke if you want to finish up, because I think you deserve a good laugh and a good chuckle. And so if everybody's done, I'll say good night with a good laugh for you, and you sleep well, and good luck with all your cases, and we look forward to hearing from you again.
Yeah, let's have a good joke. That's all else fails, laugh at it.
Okay, I know I haven't told you this one before, but how did they circumcise Moby Dick?
I don't know how.
4 skin divers.
4 skin divers, eh? I got a joke. It's a lawyer joke. Actually, it's an engineer joke. Oh, maybe it's a lawyer joke. Anyways, a lawyer dies. No, an engineer dies, and he goes to heaven. And he gets to the pearly gates, and St. Peter's there, and St. Peter says, well, you can't come here. You got to go to the other place. And so he says, okay. And he goes down, and he's in hell, and he's an engineer. So he's designing air conditioners and escalators and doing all sorts of stuff down there. And one day God gets on the phone with the devil, and they're talking. And the devil says, yeah, we got an engineer down here. We got air conditioning and escalators and all sorts of stuff now. And God says, you're not supposed to have an engineer down there. You send him up here. And the devil says, no way, we're not sending him up there. And God says, send him up here. And the devil says, nope, forget it. And God says, I'll sue. And the devil laughs uproariously, and he says, where are you going to get a lawyer?
That tops mine big time.
They're all
All the lawyers are in hell.
For liars.
That's right. All right. Thanks, everybody. We'll see you next week.
Okay, you take care, Glenn.
Well, before
See
you
ya.
go,
Thank
my
you.
little son told me a joke, and I'm sure you guys already know it. What did one saggy boob say to the other?
I don't know.
We gotta get some support around here. People are gonna think we're nuts.
There you
That's
go.
funny.
Yeah. Have a good night.
Glenn, thank
All
you so
right.
much, sir. I haven't
See ya.
met you. I haven't met you, but it's an honor to speak to somebody that's close to Glenn. I mean, Carrie.
All right. You guys take care. It's never over till you say it's over.
That's right. That's right.
All right.
Ciao,
Take
ciao,
care.
ciao.
See ya.
Onyx, that was wild.
That's a little boy's joke that my